Yeah, so I said we are discussing theories of adjudication in our jurisprudence class this morning. And before we proceed, I want us to have the question, if the law is unclear, how should a judge decide? If the law is unclear, how should a judge decide? So let's have this question at the back of your mind as we proceed. And having noted or having made a mental note of that reflective question, I would like us to first explore the meaning and scope of adjudication. And basically, adjudication may be said to be the authoritative resolution of disputes by a recognized legal institution, typically a court of law, or maybe to some extent arbitration, because they render an award as well. But in jurisprudence, when we use the word adjudication, we are talking about something deeper and heavily, philosophically loaded. So therefore, adjudication for our purposes involves the interpretation of legal rules and principles, the application of those rules to facts, and the justification of the outcome through reasoned judgment. Now, I would like you to go to our material, that is Lloyd's Introduction to Jurisprudence, the 9th or the 8th edition. I've shared the 8th edition with you, the PDF, or the 9th edition, or any other edition. Read chapter 18, where the authors discuss the theories of adjudication to supplement the lecture we are doing this morning. So, adjudication is not just about decision making, but reason-giving decision making. So let's get a distinction. Reason-giving decision making. We give a decision which is reasoned. That is adjudication. So adjudication is not just simply, resolving a dispute, but dispute is resolved through reasons that can be justified within the legal system. So let's keep that in mind. Now, how then is adjudication a jurisprudential problem? In other words, why should we concern ourselves with adjudication in jurisprudence? Adjudication is a central problem in jurisprudence because it raises foundational questions about the nature of law itself. So here, as we study adjudication, we are seeking to address the following jurisprudential tensions. One, relating to law against discretion. Are judges bound by law, or do they exercise creative choice? In other words, when judges are handling cases, are they bound by law? They don't have any room to actually operate. So we'll be looking at that tension. We also look at the tension between certainty on one hand and flexibility. Should adjudication prioritize predictability or justice in individual cases? Must we be concerned about achieving justice in a particular case? Or you should be concerned about having decisions which ensure coherence, consistency, and certainty within the legal system, even if it is not going to give justice in a particular case. And again, we are also interested in the tension between rules and principles. Is law exhausted by rules, or does it include moral principles? And we are also interested in the relationship between authority and reason. Do judges decide based on authoritative sources alone, or must they justify decisions through broader reasoning? So these tensions certainly make adjudication the practical testing ground of jurisprudential theories, and that is why it is studied as part of jurisprudence. So, first of all, let us briefly concern ourselves with the relationship between adjudication and the nature of law. What is law that judges are applying when they are deciding case? We have already met the fact that we have different theories of law. In other words, various attempts to explain the nature or phenomenon of law. And because we have different theories of law, these different theories of law produce different theories of adjudication. So therefore, if you are dealing with legal positivism, which we have met over and over again, with respect to adjudication, they will tell us that judges apply rules derived from recognized source. So you see how this theory of the nature of law is having its own particular understanding of adjudication. Again, if you take natural law, the natural law school, with respect to adjudication, will view it as that judges must align decisions with moral principles. So that for the natural law scholar, where judges' decisions are in agreement, in congruence with moral principles, then that is a proper adjudication. Also, if you take legal realism, another theory of law, they will view adjudication as this, that judges are influenced by social, psychological, and political factors. And again, if you take another theory like maybe interpretism, which we have met before, that is if you take a Dworkin's approach, Dworkin will view interpretation as that judges interpret law as a coherent system of principles. So therefore, we notice that adjudication is not neutral. It rather reflects the underlying philosophical commitment about law, as from just a brief excursus that we have seen. So, the central question, what do judges actually do when confronting cases? What do they actually do? Well, possible answers will be that judges apply pre-existing rules, in which case we are looking at it in terms of formalism, that the rules are there, and all that the judges do is that they apply them. Or another response will probably be that judges fill gaps in the law. So here we are talking of a discretionary model. So that is, they have some room of choice. There are gaps in the law they need to fill. And the third response could be that judges balance competing policies. So here we are looking at it in terms of pragmatism, practical approach, that we have a competing interests or policies which need to be harmonized, and that is what judges seeks to do. Or fourthly, we may also say that judges interpret legal principles morally, what we call interpretivism. So these responses, as we notice, reflect different theory of what? Of adjudication. But the point to note further is that adjudication is not arbitrary. If you say it's not arbitrary, what it means is that the courts or the judges are not there. Cases are just put before them, and then you say that, yes, plaintiff, you are entitled to whatever you are looking for, or the accused person is guilty or the defendant is liable. Just that, no. Adjudication operates within a structured framework. So there are some core elements. And what are they? We have legal rules. We have legal rules. So status and precedent, as the case may be. Facts will have to be established based upon evidence presented. And three, we also have procedural rules. Rules on fair hearing. You have to give the parties chance to present their cases. Natural justice, audio terram partem, nemo iudice in causa sua. Give opportunity for cross-examination for a person to confront his opponent's evidence. Then burden of proof. He who asserts must prove. If you are asserting a particular thing to exist, you carry the burden to bring evidence to convince the court that what you are saying is really the case. And then the fourth component is reasoned judgment. The court will have to provide justification of the outcome. If the court came to the conclusion that the plaintiff should be given judgment, the court must justify why. Or if the court said that the plaintiff is not entitled to win and the defendant must win, the court must justify why. If the court said that the accused person is guilty and should be sentenced to a certain imprisonment, the court must justify why. So as you can see, there is a structured framework which is followed, and that is why we say that adjudication is not arbitrary. So therefore, adjudication is rational. That is based upon reasoning. Adjudication is transparent. It's not opaque. There's no opacity as far as adjudication is concerned, because we can look at the core elements and find out what were the relevant rules, what facts were actually available in terms of the evidence adduced before the court, what procedures were followed, and what justification did the court provide. And that is why we say that adjudication is transparent. And of course, it is also subject to critique and appeal because of these elements. And anybody at all can look at the judgment and critique it. Or an appellate court, a higher court, can also look at what the judgment was. Now, from all this, we see that a defining feature or characteristics of adjudication seems to be that judges must justify their decisions. Judges must justify decision. And that is what makes the court different from all other things. Whatever decision the court will give, the court must provide an explanation to justify or account for that decision. Why the court decided in this way and not in any other way, the court must justify it. And this certainly distinguishes adjudication from political decision-making. Politicians, when they make decisions, that's political decision-making, and they rely on power. They don't need to justify their decision as the courts will have to do. Because the politician, yes, you've elected me, you've given me the power. So this is what we are going to do. If they provide explanation, it's a bonus, but it's not something that you expect necessarily. But the courts must always provide justification for their decision. Judicial decision then must refer to legal sources, provide legal reasoning, and then demonstrate consistency with prior decisions. So it's not, you don't just use anything to justify the decision. You must use appropriate sources. And those sources are the legal sources. And you must see how you reason from those sources. And also the fact that you are within a community of the legal system. So the decision that you are giving must show consistency with prior decisions, as it were. And this underpins the rule of law. So we cannot talk of rule of law without adjudication, because adjudication ensures that power is exercised according to law, decisions are reasoned, not arbitrarily, individuals can predict legal outcomes. Now, if adjudication is not structured, how can we have predictability, certainty, which is important aspect of rule of law? And that is why I would say that there is that organic relationship, or if I may even use a scientific word, there's that kind of symbiotic relationship between rule of law and adjudication. They all mutually reinforce each other. But a tension arises here. And what is that? If judges have discretion, can adjudication still uphold the rule of law? And I'd like you to look at the chapter 18 of the law jurisprudence very well. And that question is what drives much of the discussion in chapter 18 of the law's jurisprudence, which I've asked you to go and read. So if judges have discretion, can adjudication still uphold the rule of law? We often encounter what we call hard cases and the limits of law. And what are hard cases? Hard cases arise when the law is ambiguous, that is, the law is bearing more than one meaning. I don't know which of the meanings should be adopted. Precedents are conflicting. Maybe Supreme Court precedents on the matter are conflicting, or if the Supreme Court doesn't have any precedent, but let's say the Court of Appeal, and there are 3 or 4 different precedents saying different things. So we have a conflict in the precedents. And then there's a gap in the law. So in such cases, judges cannot simply apply clear rules, because certainly we have ambiguity. We have a conflict in the relevant precedents. Judges must interpret. Judges must evaluate and choose. And this reveals a fundamental truth, which is that law does not always determine outcomes. Sometimes judges must determine the law. So it's not all the time that the law determines the outcome of a case or of a controversy, because judges themselves must determine what the law is. Now, when the law is determined, before the law is used to determine the particular case. So therefore, the outcome of the case is going to be dependent upon what the law was determined to be or established to be. Adjudication, we should note, is both a legal and social process. It's not just only technical, it is also social, in the sense that judges operate within a legal culture, a political environment, and in a social context. And this makes adjudication reflect societal values, institutional expectations, and historical development of law. We should have all these things at the back of our mind as having important influence on adjudication. Adjudication has also got institutional character, in the sense that adjudication is not performed by isolated individuals. It's not just the judge, but the institution. So when we say the judge, we are talking about like the courts. So that the judge is just, if you like, a shortcut, as it were, of referring to the court. Now, what are the implications of this? First, there's a constraint in the sense that judges are constrained by hierarchy. We have a court structure. Lower courts are bound by higher courts. Decision of the Supreme Court, as we've seen at Article 129, is binding upon all courts below it. Decision of the Court of Appeal is binding upon all courts below it, and the Court of Appeal itself. Decision of the High Court is binding upon all courts below it, as it were. So, judges are constrained by hierarchy. Judges are also constrained by procedure. We have a rules of procedure, and the judges must operate within the rules of procedure. If you are dealing with criminal law, we have the Criminal Procedure Act, Act 30, as variously amended. If you are dealing with the civil cases, depending upon the court, if it's the High Court, we have the Civil Procedure Rules, CI 47, as variously amended. And also the Circuit Court, the same. And then if you are dealing with the District Court, we have the District Court Rules, CI 59. If you are dealing with the Court of Appeal, the Court of Appeal Rules, CI 19. Supreme Court, the Supreme Court Rules, CI 16. So judges are constrained by all this, and of course also legal tradition. You operate within the common law tradition. So all those things have influence. There's also the issue of legitimacy. Judicial authority depends on public confidence, perception of fairness, and consistency in reasoning. And that is why we say that justice must not only be done, justice must manifestly be seen to be done, because judicial authority depends on public confidence and perception of what? Of fairness, consistency in reasoning. These are important for the public to be confident that the courts are there to function as expected. And of course, there's this issue of accountability. Just as we have noted, must justify their decision, because their decisions could be subject to appeal, or their decisions become precedent. And that is why you must justify why you reason in the way that you did. Now, if you look at Chapter 18 of Law Jurisprudence again, they set up a key debate. The debate between the formalist view of adjudication and then the royalist view of adjudication. The formalists, what do they say? The formalists, that is those who look at adjudication in terms of formalism, it is their view that law is certain and complete. Judges merely apply rules. So judges are more or less like a bit like a robot. The rules are just apply them. And then the royalist view is that law is indeterminate. The law is not that clear-cut. Judges inevitably exercise discretion. So this is the debate which is set up if you look at the chapter that I have referred you to read. Now we talk about legal sources as one of the very important component in adjudication. And the question is, why do legal sources matter in adjudication? So what materials are judges entitled or obliged to rely upon when deciding cases? Not too long ago, I think there was a case in Ghana. I think it was a criminal case which was before a circuit court, and it has to do with like a bail or something like that. And the judge referred to animal farm and so many other non-legal material to try and justify the decision that he made. And if you remember, it made news in the country, and people were talking about it, the animal farm judge and so on. So that in itself brings up the question of the legal sources which must be used in adjudication. What materials are judges entitled or obliged to rely upon when deciding cases? Now, this question is foundational in the sense that it determines the boundaries of judicial reasoning, the legitimacy of judicial decisions, and the relationship between law and morality. You cannot just use any material at all to guide your decision. You must use acceptable material. So, we cannot understand adjudication without analyzing the sources from which law is derived and justified. So what then are legal sources? Legal sources are the authoritative materials recognized within a legal system as providing the reasons for judicial decisions. So the emphasis here is on authoritative materials recognized within the legal system. So therefore, they answer the question, why is this decision legally justified? Why is this judgment or this decision legally justified? And that is answered by whether they were based upon the legal sources, that the authoritative material recognized within the legal system as providing reason for judicial decision. Now, in that respect, we could say that legal sources serve three key functions. One, they serve as authority in the sense that the legal sources or those recognized materials legitimize judicial decisions. They give legitimacy to the decisions of the court. Two, they serve as a constraint on judges in the sense that they limit judicial discretion, meaning that, yes, even if there's a judicial discretion, if there's a room for choice, it doesn't mean that it's a blank check. You have the whole sea before you and you can do anything. Or as Alice in Wonderland, to play Humpty Dumpty or things. No, you are constrained because you must use the proper legal sources. And thirdly, continuity. They ensure consistency across cases in the sense that we have the sources defined there. So if those sources are being used, if you have like a similar, factual scenario, we can expect that the outcome is going to be the same or near similar because it's the same legal sources which are being used. Now, legal sources are not the same, they are not monolithic. We have a hierarchy and typology, which may be identified. So first, we can talk of a formal or binding sources. So these are sources that judges are obliged to follow. If you look at we have the constitutional provisions, the statutes, judicial precedent. So if you look at our Article 11 of our Constitution, we have the sources of law in Ghana. And Article 11 sources in our present discourse will be the formal or the binding sources. In the sense that judges do not have a choice. They must follow those sources. And these sources derive the authority from sovereignty. So constitution, the legislation, and also institutional hierarchy, that is, precedent, as it were. And two, we may also classify legal sources as persuasive sources. Persuasive sources influence, but they do not bind. Academic writings, writing of jurists. If we take like a book by John Mensah Saba on family customary law, or you take the book on maybe land law and conveyancing by Dennis Dominic Ajay, Professor said Dennis Ajay, my lord, or let's name it, Professor Tukuba's work, the new Constitution and Administrative Law of Ghana, from the Garden of Eden to 2022. So those are just examples, or taking note of my works. Those are just examples. They are not binding. Then foreign decisions from foreign courts. They are persuasive. They are not binding. And again, obiter dicta, statements which are made as a side comment by judges when they are deciding cases. Nobody will say side check in the law. I'm not talking about that. I'm talking about side comments. So that is obiter or dicta. Then policy arguments. Policy arguments also are persuasive. They are not necessarily binding, as the case may be. So here, those persuasive sources operate through persuasion, not authority, unlike the binding or the former binding source that we mentioned. We also have maybe extra legal sources, maybe moral principles, social values, economic considerations, public policy, as the case may be. And they are also some sort like a source. Now, if you look at the legal positivists, they have their own view on sources. For them, law is identified by social sources, no moral content. We know what Hart has told us already. That law consists of rules recognized by officials. And then he talked about the rule of recognition, who determines valid sources of law. We've made that already. And for that matter, under positivism, a legal source is valid because it satisfies criteria accepted within the legal system, not because it is morally right. And this has implications for adjudication. Judges should rely on recognized legal sources. Moral reasoning is secondary or excluded. I mean, that is for the positivists. But if you take positivists too seriously, you encounter some challenges. Legal rules do not cover all situations all the time, so there may be incompleteness. And again, we also have the problem of ambiguity. Language in statutes and precedents is often unclear. It's capable of bearing more than one meaning. And we need to select which of the competing meaning, for example, is the appropriate one. Another problem with positivist view of sources for adjudication is that different sources may point in different directions. So we still have a problem. And again, remember Ronald Dworkin, and Ronald Dworkin challenged the positivist limitation of sources. And as you remember from our previous lectures, his basic or core argument is that, that is Dworkin, that law consists not only of rules, but also of principles. And these principles do not derive from formal documents. These principles are grounded in moral reasoning embedded in legal practice. So, for example, fairness, equality, justice. And the fairness, for example, let's say that no person shall benefit from his own wrong. So that where somebody is a beneficiary under a will, but they establish that he's the one who killed the testator. Despite the fact that the testator made a provision for you under the will, because you are the killer of the testator, you will not be allowed to benefit from your own wrong. So that is the principle of fairness. Now, what this implies for adjudication is that judges may rely on moral principles as part of the law itself, not as external additions. Unlike what positivists or lie to tell us. So this is what the Dworkin is adding. So therefore, legal reasoning for Dworkin includes both authoritative sources and moral justification. Of course, we also know the legal realists, the American legal realists and the Scandinavian legal realists. Now, the legal realists, they shift the focus from formal sources to actual judicial behavior. And for them, what counts as a source of law in practice depends on judicial attitudes, social context, and institutional practice. So therefore, for the legal realist, the rare sources of law may include psychological, political, and social factors, which influence judges. And for that matter, when it comes to adjudication, for them, formal sources may mask, that is conceal, that is cover the rare decision-making processes. Now, if you strip the mask, you see that there are some other things like psychological, political, and social factors which actually influence the judges. Then formal sources also provide post hoc justification. That is what they call the, as somebody would say, ex post facto rationalization, meaning that the judges have actually made up their mind in a particular way, but then all that they need to do is to try and look for reason from the formal sources to justify their, their outcome. So therefore, it's not the formal sources per se which made them reach that outcome. They've made up their mind. But for the decision to be acceptable, they need to use, the formal sources to justify it. Well, can we say that it happens sometimes, probably in the Supreme Court, where they announce a verdict and they say the reasons will be provided later? Well, that's something for us to think about intellectually. Now, judges do not just discover sources. That is what the sources of law are. Judges select, interpret, and prioritize them. And this introduces an element of choice. What do you mean by that? So if there's a matter being decided, the court or the judge will need to decide which precedent is relevant to the case. And you remember the technique of distinguishing and say that yes, this precedent can be distinguished from the present case, and for that matter, we're not going to follow it. Again, the court must decide which interpretation of a statute is correct. Because interpretation, as we've noted, there will be ambiguity. The text of the statute may bear more than one meaning. And the court will have to extract the legal meaning, will have to select the most appropriate meaning. And that one in itself is an exercise of choice. Again, which principle should prevail? Which principle should prevail? Now, in the light of all these issues, we notice that legal sources are not self-applying. In other words, you have Article 11 of the Constitution there. The Constitution, the status or Acts of Parliament, existing law, the common law, precedents, customary law. These are the sources, but they are not self-applying. Not self-applying means that they by themselves cannot give outcome to cases. They require judicial mediation. Judges will have to activate, operate, and manipulate them. So, we have a major challenge in adjudication. And that major challenge is this. When sources conflict, so for example, we have a conflict between what the provision of an Act of Parliament is saying on the one hand, and maybe what a Supreme Court decision has said, just as an example. Or you may have a situation where we have a competing precedent. It has happened many occasions. Supreme Court has a different precedent on the same matter. So, in terms of Article 129, Clause 2 and Clause 3 of the 1992 Constitution, that decisions of the Supreme Court are binding on the Supreme Court, and unless the Supreme Court finds a reason to depart from it, and all lower courts are bound to follow the decision of the Supreme Court. So here's a case we have a competing precedent. So which one should be followed? You may also have like a conflict between a rule and principle. So in the light of these tensions, what should be the judicial task? The judge must resolve the conflict. The judge must justify prioritization. And this in itself reveals that adjudication is evaluative and not mechanical. So we've seen the hierarchy of sources already. If you look at the Constitution in Article 11, is not stated, but implicit in the arrangement, you see some form of, especially a hierarchy in the sense that the Constitution is in its own category. And the supremacy of Constitution doctrine. All other laws must conform to it, so there's no doubt about that. And of course, status quo in relation to delegated legislation, we also see that kind of the hierarchy, not that which one comes first. And then precedents. Now, we also have legal reasoning. In other words, having the sources. What approach should the judges use to reason? So legal sources shape the structure of reasoning, that is coming to a decision, the outcome. So we have what we call the deductive reasoning, where you reason from a statute or the rule to the particular outcome. Then we have analogical reasoning, where you reason from precedent. If this scenario happened in this decided case, then if you can establish a similar scenario in the current case, the outcome should be that. Then we also have what we call the evaluative reasoning. That is where you try to reason from principles and policies. So sources or the legal sources do not just determine what judges use to reach a decision. They also determine how they reason. So that is the point that we have to note. Another point we have also noted is that when it comes to adjudication, it's not just the individual judges, it's the institutional actors. So the court is the institutional decision maker. And the courts, as we know, are the formal institutions vested with authority to interpret and apply the law. So the courts have independence from political branches like the executive and the legislature. The courts must adhere to procedural rules, as we have seen. And then the courts have obligation to give reasoned judgments. And there's also hierarchical organization or structure of the courts. Supreme Court, Court of Appeal, High Court, Circuit Court, District Courts, and other quasi judicial bodies, as it were. And we have noted that courts differ from other decision-making bodies because courts must justify decisions in legal terms. They must use the law to justify their decision. Courts must operate within a framework of precedents. And then courts are subject to review and appeal, as the case may be. So we know the structure of the courts already, so we will not belabor the point, except to say that we have the trial courts. And then after the trial court, we have the intermediate or the appellate courts. Intermediate or the appellate court means that in Ghana, for example, the High Court is an appellate court over decision from the district courts, as it were, civil and criminal cases. and then criminal cases only with respect to circuit court. And then we go to the Court of Appeal in that order. And after the Court of Appeal, we have like the final or the appellate court, that's the Supreme Court. Now, because of this structure, as we have seen in terms of Article 129, the lower courts are bound by the higher courts. The higher courts, that is, will shape the development of the law. So, judicial reasoning at each level of the court is influenced by fear of reversal and desire of consistency. So, if you're a judge in the district court, you're a judge in the circuit court, in the high court, in the Court of Appeal, you have the concern that if your decision is not properly reasoned, it may be reversed on an appeal. Or if you don't follow procedural propriety, it may be a candidate for certiorari in a judicial review application. And all these things serve as important factors in shaping judicial reasoning. Now, in terms of the institutional constraint on judges, we have noted that judges do not decide cases freely. Judges are constrained by institutional factors. We talk about precedent, that judges must follow binding precedent, even if the judge disagrees, so long as the precedent is relevant and applicable, the judge must follow it. Judges are also constrained by procedure, rules of evidence. We use evidence to establish facts, and it is the facts or the facts are the things which are going to serve the basis for deciding the case. It's not anything at all which can be entertained by the court as a material to help the court to establish existence or non-existence of facts. So we have a whole law on evidence, who determines matters of admissibility, what can be admitted, who determines matters of relevancy, the matters of probative weight or value. So all these serve as important constraining mechanism. Judges cannot just pick and choose anyhow what to accept as evidence. No, they must filter it through the law of evidence. And we've talked about burden of proof. You can't just make assertion. You must actually prove it. And we have a fair hearing requirements. I mentioned cross-examination. You cannot just give evidence and expect that the court to work with your evidence when your opponent has not been given opportunity to challenge you on the evidence. And challenging you on that evidence is called cross-examination. And that is also a way of hearing both sides of the matter. And of course, the person who is also deciding or hearing the matter itself must also not be conflicted, as it were. Another procedural or constraint or institutional constraint has to do with jurisdiction. As we know, we have limits on subject matter, on authority. Depending upon the level of the court, the location of the court, matters that you can deal with and matters that you cannot deal with. So that if a judge, for example, give a decision which is outside his or her jurisdiction, that decision suffers from problem of legitimacy, and it will be quashed as being void. Another constraint, institutional constraint, is collegial decision making. And collegial decision making actually applies to the appellate courts, Court of Appeal, and the Supreme Court. In the Court of Appeal, in the Supreme Court, decisions are collective. Collective in the sense that it's not just a single judge who is sitting to decide the case. We have a panel of judges. Court of Appeal have 3 judges. Supreme Court, we have 5 judges or sometimes 7 judges who are deciding a case. And it makes the decision not just an individual decision, despite the fact that there may be like separate opinion, but in terms of like the outcome, is a collegial decision. Now, all these constraints ensure that adjudication is not arbitrary. It is structured. It is disciplined. It is predictable. So let's keep this in mind. I would like all of you, I mean, the chapter 18 is just like the few, just a few points. I'd like all of you to read all so that you have like a complete picture of what we are trying to discuss. We have already touched on the rule of procedure in adjudication, and in terms of procedural rules, they have a particular function. When we are talking about adjudication, they ensure fairness. Fairness in the sense that we're giving an example like the audio theorem pattern. They also structure presentation of evidence so that we all have like the ground rules regarding what can be accepted as evidence and what cannot be accepted as evidence. The procedural rules also limit issues before the court. Issues before the court are questions which must be answered by the court, questions which must be determined by the court. And then procedural rules also promote efficiency. Efficiency in the sense that everything is well programmed, everything is well calibrated, so that we're able to know what should be accepted as part of the case, what should not be accepted as part of the case, and then they can make a good progress towards conclusion of the case and know the outcome. So what all this implies is that substantive justice is not in vacuum. Substantive justice is premised on procedural unfairness. So therefore, a correct decision reached through unfair procedure undermines a legitimacy. What do you mean by this? A court might have given a decision in terms of outcome, which is good, which is just, but if the procedure was not right, there will be question of legitimacy of that decision. We also have the adversarial nature of adjudication. And being in the common law tradition, we know that adjudication operates through an adversarial model. And the features are that parties present competing arguments. Judges act as neutral arbiters. And then evidence is party-driven. So this is adversarial litigation. So judges have folded their hands. Okay, plaintiff, what are you saying? Yes, tell us your case. Have you finished? Your opponent will have confronted you. If all is that, okay, defendant, tell us your case. Have you finished? The plaintiff have also confronted you on your case. Now, when it is done, then the judge, as a neutral arbiter, will render his decision. So that's adversarial. So judges depend on argument presented by counsel. And that is why where some certain arguments have not been made, the court cannot make it. Otherwise, the court will be accused of substituting a case for the party. The court cannot set up a case ex proprio motu or meri motu on its own, set up a case for a party. That is not right in the adversarial model. So the implication is that the quality of adjudication in adversarial model may depend on advocacy That is the competency of the the lawyers to present the case of the parties, as well as the resources of the parties. Sometimes it's a question of gathering the appropriate evidence. For example, you are doing a medical negligence case. If you are the plaintiff and you don't think of the fact that it's necessary for you to go and engage your own medical experts to review the clinical notes and whatever happened, to also give you their own independent expert view. And then they come and testify in the court and just go to the courtroom and just say that a relative of yours died as a result of medical negligence. Yes, the death might have occurred, but you would not have succeeded in setting up a proper case to let the court come to an outcome which you are looking for, because you didn't do the needful. Probably didn't have the resources to do the proper gathering of evidence. So all these matters affect the quality of what? Adjudication. So adjudication is partly shaped by the litigation dynamics, as we have seen, and not just legal doctrine or only the law. So many things affect adjudication. Another defining feature of adjudication is judicial independence. Independence means that the courts have freedom from executive interference, security of tenure, financial autonomy. Impartiality also means that there's no bias towards the parties. No bias towards the parties. Decisions are made based solely on the law and facts. And these principles ensure public confidence and legitimacy of what? Of judicial decisions. So, institutional adjudication, that is like the courts, derive legitimacy from several sources. From legal authority, that is, decisions are made based upon the law as derived from the Constitution, the statutes, the appropriate precedents. And then procedural fairness, parties are heard and treated equally. Three, reasoned decisions, judgments are justified logically, as it were. Logically in the sense that this is the law, this is the evidence which came, and if this is the law, if this is the evidence, then this outcome we think is it. You can follow it, some kind of like a logical structure. Then there's also consistency. Similar cases are treated similarly. And that is the point about precedent. So legitimacy for adjudication is not automatic. It must be continuously earned through institutional practice. And that is why we say that the courts are the last hope of society. When we say that, they're referring to some of these matters, because we know that the courts will do adjudication in a legitimate way with all the consideration that we have been exploring. Now, the role of appellate courts is critical as far as the institutional role of adjudication is concerned, in the sense that appellate courts correct errors of lower courts. When the lower courts have made some errors, it will be corrected on appeal. Or they also clarify and develop legal principles and ensure uniformity of law. Now, that function of appellate court has impact on adjudication, in the sense that because of the awareness that if error is made, it will be corrected by the appellate court, the lower courts will try and do structured reasoning. The district court, the circuit courts, high courts, and so on, they will try and do structured reasoning, knowing that if they don't do that, it will be corrected on appeal. It also promotes legal coherence and shapes future adjudication through precedent, as it were. But of course, we must also note and appreciate institutional pressures on judges. Judges operate under various institutional pressures. So we have like the caseload pressure, for example. Let's say the High Court, typically, a judge will be given not less than 250 cases to handle. So there's a need for efficiency. And there's also the risk of superficial reasoning because of the caseload. Judges may not have the energy and the time to apply themselves comprehensively to all cases. So there's that risk of superficial reasoning. We also have presidential constraints, which limit freedom in decision making. Judges are sometimes limited in deciding matters because of a binding precedent. Even if the precedent is not even great because it's binding, it will have to be followed. And of course, a public expectation, a demand for justice and fairness. There are some cases where the public will put so much pressure on the judges. Not too long ago, we had a case, I think a divorce case, where the judge is heard to have said that marriage is not an investment or something like that. And we also what came out of it, and then that the Lumbers case. So you also remember it. Team legal wife, and then the team what do they call it, the Odobroni, and so on. So all these serve as pressure on judges, public expectation. Another thing we've also noted is collegial dynamics, influence of other judges in appellate courts. So in appellate courts, the judges sit in panels, and that also serve as a pressure on each other, as it were. And these pressures influence how judges reason and decide cases. So all that should be appreciated. So adjudication then is a public function. It's not a private activity. Adjudication is not a private activity, it's a public function. A public constitutional function, I should say. What are the public dimensions? Decisions affect society at large, and cases are decided. Judgments shape legal norms. So, for example, when it comes to spousal property right, you've seen the recent decisions of Supreme Court. Again, court acts as guardian of rights. For that matter, adjudication serves dispute resolution function, serves law development, and also constitutional governance. Now, there's also a relationship with separation of powers. So, adjudication and separation of powers. Yes, within the context of separation of powers, the role of judges is to interpret and apply law, not to legislate. That is, not to formally make law. That one is the remit of the lawmaker, the legislature. But we have a tension. Tension in the sense that judicial interpretation may resemble lawmaking. In what ways? Particularly when it comes to constitutional cases, when it comes to constitutional litigation, some of the decisions of the Supreme Court, they may have the character of lawmaking in a sense. And again, even outside constitutional litigation, when it comes to hard cases, that is, those cases where the position of the law is not clear, where there's no binding precedent, there's no applicable, if you like, a rule, and then the court will have to navigate the particular rule which will guide them. So those are the hard cases. Now, when it comes to those type of cases, we see judicial interpretation appearing as a lawmaking. That is the point we are trying to make. So where does interpretation end and legislation begin? That is a key question. Where does interpretation end and legislation or lawmaking begin? Of course, there are institutional limits of adjudication. Courts are limited in what they can do. That one is a fact. Unlike lawmakers, they can decide to make law on anything which is of interest to them. Parliament can say that we are going to make a law on the use of aboboya on our roads. We are going to make a law on this and that. That's it. But courts are limited in what they can do. Courts are reactive in nature. When we say courts are reactive in nature, that is to say that courts act only when cases are brought. The Supreme Court, or for that matter, any court, cannot just say that we think that these issues going on in society need to be addressed. So we have sat to give a decision. No, courts don't behave like that. Courts act only when cases are brought. Now we also have the fact that in terms of courts and adjudication, one of the institutional limits is that we have to go the case-specific decisions. The court must focus on the parties, not general policy. Although we say that the Supreme Court is a policy court. Supreme Court being policy court doesn't mean that the Supreme Court can just be giving pronouncement and direction on matters which are not relevant to the controversy which was presented to them. The court must always focus on the disputes, not just general policy, unconnected to the matter before it. No, the courts cannot do that. And that's why I say that case-specific decisions is another institutional limit as far as adjudication is concerned. Thirdly, there's also limited fact-finding. Limited fact-finding in the sense that the courts must actually limit themselves to the evidence presented. If evidence is not presented, the court cannot make a fact-finding on that. There's also a lack of enforcement power. The courts make decisions, but the court need the executive to help the courts to enforce their decisions. So the courts rely on executive enforcement. So that is another tension with the separation of powers. If the courts make decisions, when it comes to execution, you need the police, as it were. And even sometimes the military, depending upon what is at stake. Adjudication and policy making, we have noted that although courts are not policy makers, they inevitably engage in policy reasoning. Courts are not policy makers, but what they do ultimately amounts to policy reasoning. Policy reasoning is not necessarily the same as being a policy maker, so let's get the distinction. When it comes to constitutional interpretation, there's a policy reasoning. When it comes to involvement of the common law, for example, negligence. If you remember, especially when it comes to recognition of a duty of care in novel situations, you read, the Caparo and Dickman, reasoning, for example, where sometimes the court will find out whether it is just unfair to recognize a new duty situation. These are all policy reasoning, as it were. So the question is, of course, judges also balance competing interests. When judges are balancing competing interests, it's also policy reasoning, especially when it comes to nuisance. For example, nuisance, people in the residential area and somebody doing a certain project, and those in the residential area say that their quiet enjoyment is being interfered with by the noise and other usual substances. And then the person doing the project also needs to pursue a legitimate economic interest. So the court will have to balance competing interests. So that is a policy reasoning. So the debate is, should judges engage in policy making or strictly apply existing law? Well, that is something for us to reflect on. But institutional context of judicial reasoning must be appreciated. The institutional setting influences how judges reason. We've talked about the fact that adjudication should be formal reasoning in the sense that you rely on precedent, rules, and so on. Again, incremental development in the sense that unlike lawmakers, parliament can just make any law at will. But judges will have to avoid radical change. So if you read decision, you notice that development of the law is quite gradual. There's also justification culture. There's emphasis on reasoned opinion, as we have noted. And there's also institutional conservatism. When it comes to adjudication, there's that preference for stability. So don't have radicality. If you look at the courts and the way the courts reason, judicial changes are not that radical, as it were, in terms of reasoning. Because judicial reasoning is shaped by the need to maintain institutional continuity and legitimacy. So let's say a few things about stare decisis, the doctrine of precedent, which at this stage of your legal training, being in the final year, for that matter, to learn jurisprudence, you have learned this over and over again from your first year in legal system and legal method. But for our present purposes, we need to revisit an aspect of it as a refresher. So the doctrine of stare decisis, that is, which simply means that stand by decided matters, is cornerstone of adjudication, particularly in the common law systems, as we know by now. And it basically embodies the principle that like cases should be decided alike, unless there is a compelling reason to depart. And this is consistent with what even the Constitution. If you look at Article 129, Clause 2 and 3, I quote, "The Supreme Court shall not be bound to follow the decision of any other court." Clause 3, "The Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decision of the Supreme Court on the questions of law." Good. So, like cases should be decided alike unless there's a reason to depart. So precedent then is both a source of law and a method of reasoning. It's a source of law, especially if you look at Article 11. At the same time, it is also a technique or method of reasoning. It is a mode of judicial thinking, as it were. So let's explore the conceptual foundation of precedent. At its very core, stare decisis rests on two ideas. One, consistency. The fact that similar facts should give rise to similar outcomes. So that is the need for consistency. Two, institutional continuity. Law develops gradually over time. So precedent transforms adjudication from individual decision making into a collective historical process. Although one judge is certain making a decision, because of stare decisis, because of precedent, it's not just he or she alone making a decision. He is actually following or forming part of a collective historical process. So in terms of structure, precedent looks like this, as we know. Two main components. We have the ratio decidendi, which is the binding legal principle, the reason necessary for the decision. So if you have a case, you will lay down a principle which governs that decision or the reason for the decision. So that is a ratio decidendi, and that is a binding aspect of the case. Then two, we have what they call the obiter dicta. Statements, if it's more than one, we say obiter dicta. If it's just one, we say obiter dictum. Statements made by the way. They are not relevant or germane to the question before the court. For that matter, they are persuasive, they are not binding. Now, the distinction here is pertinent in the sense that it determines what must be followed and what may merely influence. The ratio decidendi certainly is a binding precedent, and then the obiter dicta may influence in later cases depending upon its weight. So for that matter, we have a binding precedent on one hand against persuasive precedent. Binding precedent must be followed by lower courts, as we have seen in terms of Article 129 Clause 3 of the Constitution. Binding precedent arises from the higher courts in the hierarchy, and also sometimes courts of coordinate jurisdiction. Persuasive precedent may influence but not compel. So they include decisions from other jurisdictions, obiter dicta, academic writings, and all that. Now we have vertical and horizontal operation of stare decisis. Now, when you talk about the vertical stare decisis, that is to say that lower courts are bound by higher courts, so that is vertical. So, district and circuit courts are bound by high court. Don't say that the district court is bound by the circuit court. No. The district court and then the circuit court, they are not courts of record. They are not superior courts. They are lower courts, or what we call inferior courts. Their decisions do not serve as precedent. It will serve as res judicata, right? For purposes of saying that the matter has been litigated before, so it should not be re-litigated, so res judicata. But that is different from judicial precedent. So the district court, the circuit court are bound by decisions of the high court. And then the high court is bound by decision of the court of appeal. And then court of appeal is bound by decision of the Supreme Court. So that is a vertical operation of stare decisis. And I also have horizontal stare decisis, or horizontal operation of stare decisis. That is, courts are bound by their own previous decisions. So if we take Supreme Court, for example, Article 129 Clause 2, despite saying that the Supreme Court is not bound by the cause of any decision of any court lower than the Supreme Court, Article 129 Clause 3 goes on to say that the Supreme Court ordinarily must follow its own previous decision unless it appears to it right to depart. Meaning that the Supreme Court is even constrained by precedent. And this point needs to be appreciated. The Supreme Court, yes, can depart from Supreme Court decision, but it must do so properly. And let us know that you are aware that this decision is relevant to the matter before you, but for whatever reason that you have stated, you are departing from it. In that case, you are released from the strictures of Article 129 clause 3. Otherwise, the Supreme Court must follow its own decision. And in that case, stare decisis is operating horizontally. So that is the horizontal stare decisis. The courts are bound by their own previous decisions. And of course, that one for the other court below Supreme Court, it goes without saying that they are bound by their own previous decisions. So this creates a network of legal authority which ensures coherence. Now, in terms of justification for legal precedent or stare decisis, as we have seen from your legal system and legal method, it ensures legal certainty. Individuals can predict legal outcomes. Then there's a bit of like equality here because like cases are treated with like. There's also efficiency. Avoids re-arguing certain principles. There are a lot of cases in which the courts do not have to waste their time to try to establish the governing law because the governing law is so settled. And all that the courts will have to do is to apply it to the facts before it. It also ensures stability, promotes continuity in the law, and also enhances institutional legitimacy. Decisions are not arbitrary. Decisions are principled, and that is good. But of course, there are downsides, or there are some criticism as well. We have the problem of rigidity, as what is presented by stare decisis, because stare decisis may perpetuate outdated or unjust rules. Some precedents are not fit for purpose, but because they are binding, courts will say how to follow them. Then formalism, sometimes with emphasis on technical distinctions. There's also the problem of illusion of certainty. Precedents may not always ensure certainty because precedents may even be ambiguous or may be conflicting. And again, precedent or stare decisis is a constraint on justice because strict adherence to stare decisis may lead to unjust outcomes. There are times that courts are giving decision, and if you look at it, the decision will have been different if not for a particular binding precedent. So here you have unjust outcome. But the good news is that there are techniques for avoiding precedent. So there are times judges may not have to rigidly apply precedent. So one, distinguishing. Distinguishing, that is a very powerful technique for avoiding rigid application of precedent. How does distinguishing work? That is, the court will show that the facts in the case presently before it differ materially, significantly, from the facts in an otherwise binding precedent. So if the court can actually demonstrate that, if you look closely at the facts before us and then the facts in that otherwise binding precedent, there's some material distinction, then we don't have no same cases to be treated alike. So we are not going to follow it. So you distinguish it. Another technique is overruling. High court rejects previous decisions. So Supreme Court can overrule its decisions, or Court of Appeal can overrule decisions below it, as it were. Then reversing. Appellate courts overturn decisions in the same case. That is also another way. And sometimes narrow interpretation. That is, you limit the scope of the ratio decidendi. The ratio decidendi is the reason for the decision, and that is the binding part. Now, the ratio decidendi will have to be extracted by interpreting the decision. And in doing that, you can narrow the ratio. So if you narrow the ratio, what it means is that it may not be applicable to the particular case before you, so that you are not bound to follow it. Then we also have making a declaration of per incuriam. If decision was made with an otherwise binding precedent, if that decision was made in ignorance of the relevant law. Or maybe there was an applicable statute which was ignored, which was not even mentioned. Then, if you can point to the fact that if you read the decisions and clearly this applicable legislation was not taken into account, and for that matter, we don't consider it as binding. Not even binding, it's per incuriam. Per incuriam means that it's given in error. It's a wrong in law. So if a decision is per incuriam, it loses its presidential value. Because for a president to be president, it must be consistent with the law. Now, we also have this challenge. That is precedent and judicial creativity. There's a tension between constraint and creativity. So there are two schools of thought here. You have the traditional view and then the modern view. The traditional view is that judges declare existing law. That all that judges do is not to do anything but to declare the existing law. Then, the other school of thought, which you call like the modern view, is that judges develop law incrementally through precedent. That is, gradually, judges develop or make law through precedent. And for that matter, precedent allows stability and gradual evolution of the law. Now, precedent, as we have noted earlier, is not only a source, but it's a method of judicial reasoning or decision making. So precedent as a reasoning by analogy. So precedent operates through analogical reasoning. When we say analogical reasoning, just from the word analogy. So analogy, the analogical. So precedent operates through analogical reasoning, and the process involves that the court will identify the relevant past case, okay? Then the court will read the relevant past case and try and extract the principle or the ratio. Then 3, the court will compare the facts of that case, that relevant past case, with the facts of the case before it. And then 4, the court will try and find out if the facts are the same, then it will apply the ratio which was extracted from that case to this particular case. But then if the facts are different, the court will distinguish. So therefore, it will not apply the ratio extracted from that relevant past case. So this analogy or this analogical reasoning requires judgment. As you can see, the court will have to make a judgment in terms of what similarities in the present case before it and in the past relevant case are. You must try and find out, are there some similarities? Are there material similarities? And 2, what differences are relevant? What differences do I see in the case before me and then the past relevant case? So in all this, the court is forming a judgment, is forming an opinion, or is doing evaluative work, an exercise. So precedent is not mechanical. Precedent is interpretive. Now, if you read chapter 18 of the Law's Jurisprudence, as I've asked you to read, it will address the problem of indeterminacy of precedent. Precedent is often indeterminate. Indeterminate means that it is not settled, in the sense that multiple precedents may apply. The ratios may be unclear, and cases may conflict. So this leads to judicial choice in selecting and interpreting precedent. Judges will have to decide which, president to adopt and follow. And that is why we said that the president shapes judicial reasoning. We talk about the deductive use, applying established rules, and then we just talk about the analogical use, comparing similar cases, and then interpreting use, extracting meaning from prior judgments, and also creative use, extending or limiting principles, as it were. Now, if we look at precedents and theories of adjudication, we notice that different jurisprudential schools interpret precedent differently. So if you take the school of formalism, that is the formalists, they hold the view that precedent is strictly binding. Judges apply rules mechanically, just like robots, as it were. Now, if you take the school of legal realism, they hold the view that judges manipulate precedent. They manipulate precedent to justify their preferred outcome. And then they also make the point that decisions are influenced by extra legal factors. That is, factors other than law, psychological, sociological, political, and so on. Now, if you take Joaquin, which we have met earlier on when we discussed Joaquin's interpretivism, Ronald Joaquin holds the view that precedent reflects underlying principles so that judges interpret law as coherent whole. And if you remember his famous chain novel analogy. Now, from the point of view of rule of law, precedent supports rule of law by promoting consistency and also by limiting arbitrariness and also by enhancing predictability. These are all important aspects of rule of law, and that is what precedent seeks to do. But the problem we have is that precedent creates a tension in the sense that strict adherence to precedent may create lack of justice in individual cases. So that is the challenge that we have. Now, if we may want to ask at a deeper level, why precedents? So the normative question, why should past decisions bind present ones? Why should decisions made by 100 years ago bind us today? Decisions made 20 years ago, 50 years ago bind us today. Why? Why should past decisions bind present ones? Now, this is a normative question about justification of legal authority. Are there moral, institutional, and practical reasons for adhering to precedent? Now, the core principle, as we have noted, is treating like cases what? Alike. So justice requires that similar cases be treated similarly, as it were. Similar cases be treated similarly. And that principle is grounded in fairness. Because if we are treating similar cases similarly, then you're ensuring fairness, isn't it? Equality before the law. And then rationality in decision making. And this precedent we are talking about is something, it's not only in adjudication, in everyday life. I remember in my family, for example, I have daughters. If one daughter is doing something and we, for example, say no, or we try to prevent her from doing, she will try and go to the archive of our family platform pictures and try to retrieve a similar thing, which was done by one of her sisters, and try to use that to build the case that what she's seeking to do is not different from what the sister did, and we approve it at the time. So here, you see that trying to treat similar cases alike, as it were. And of course, a legal system that fails to treat like cases alike risks appearing arbitrary. If like cases are not treated alike, then you are just being arbitrary or playing Humpty Dumpty. There's also a problem of you being unpredictable, and for that matter, you're unjust. So the most powerful justification for president is the need for legal certainty. And the rationale is that individuals and institutions must be able to predict legal consequences and plan their affairs accordingly. And that's very important. So, precedent enables stability in commercial transactions. When businesses are structuring contracts and arrangements, they should have the confidence that if this happens, based upon what has been held before in other cases, this is going to be the outcome. So there's that stability. There's also confidence in legal rights. And precedent also reduces the risk of litigation. Without precedent, the law will be unstable and non-reliable, as we can see. Again, precedent promotes efficiency and judicial economy. There's efficiency in adjudication in the sense that precedence reduces the need to re-argue certain principles. There are a lot of areas in the law which is so settled that you don't need to re-argue it fully all the time. No, you just apply it to the facts. So it saves judicial time, streamlines legal reasoning. And then, so you can have a situation where a court will, for example, say that the application by the plaintiff applicant is granted in accordance with the decision in X and Y. That is it. You want to know, you go and read X and Y. So you save judicial time. And precedent enables the court to focus on new issues and avoid duplication of reasoning. And that is why we say that precedent contributes to the effective administration of justice. Again, there's also institutional legitimacy and public confidence. If you adhere to precedent, it enhances legitimacy of the courts. Why is that? Because decisions appear principled, not personal. Decisions are rendered not because of what the judge would like to do, but because it's in accordance with the established precedent. Judges are seen as following law, not preference. And this have the result of increasing the public trust in adjudication and acceptance of judicial authority. And for that matter, a system governed by precedent appears more objective and neutral. And that is very important for public confidence in the judiciary. And again, precedent serves as a check on judicial discretion. It limits arbitrary decision-making. And it ensures continuity across different judges. Judges come and go. There have been so many judges ever since 1876 Supreme Court Ordinance, which formally set up the modern court system. Many judges have come and gone, but because of precedent, we have that kind of continuity, as it were. And this is important. In a system where judges are unelected, especially in Ghana, judges are not elected. President provides a mechanism of accountability through adherence to established law. Judges are not accountable to electorate. Judges are accountable to fidelity to precedent. Now, we also have formal justice as against substantive justice. Formal justice here will mean consistency in applying the rules. And substantive justice means achieving morally correct outcomes. So the tension we have is that when you strictly adhere to precedent, it may promote formal justice and undermine substantive justice. That is the problem. And you've already also seen the problem of like the rigidity of precedent already. Now let's say a few things about judges and discretion before we wind this up. Now, do judges exercise discretion when deciding cases? So that is the central problem of adjudication. Do judges exercise discretion when deciding cases? Now, this question is pertinent and pervasive in the sense that it determines whether law is certain or indeterminate, whether judges are bound or judges are creative, whether adjudication is objective or subjective. And here, discretion is to be seen as a pivot or the fulcrum around which competing theories of adjudication revolve. So first and foremost, what is judicial discretion? Judicial discretion refers to the freedom of a judge to choose between alternative legally permissible outcomes. So meaning that we have various legally permissible outcomes and which of them to choose. So the freedom to choose, that is the discretion. It arises where the law is uncertain, the law is incomplete, and then the law is conflicting. Then there's an issue of what? Judicial discretion. But let us know that discretion does not mean arbitrariness. It doesn't mean that it can just do anything at all. No. Rather, it involves reasoned choice, justification within legal framework, as we have been exploring this morning. Now, there are types of discretion which may be identified in the literature. So we have weak discretion and then a strong discretion. What is a weak discretion? In terms of weak discretion, judge interprets and applies existing law. Judge interprets and applies existing law. So here, there is limited flexibility. So that is weak discretion. And we have a strong discretion. Judge creates new legal standards where law is silent. So the law is silent and the judge will create a new legal standard. So that's why I said a strong discretion. And as we notice from the debates we have met earlier on between Hart and Joaquin, where we see the weak discretion and the strong discretion coming up. So that is what we are following on in our present discourse. Now, the formalists, that is those who believe in formalism, they deny discretion. And their core claim is that law is complete and determinate. Judges merely apply it. Now, this core claim they have is based upon assumptions they hold. And these assumptions are that, 1, legal rules cover all cases. 2, language is clear. And 3, judicial reasoning is mechanical. So these are the assumptions which they make in saying that law is complete and all that judges do is merely to apply it. So the implication is that judges do not make law as far as the formalists are concerned. They declare it. Of course, there's a challenge with such a formalist view because in complex cases, it's unrealistic. It's not all the time that the law is so clear-cut. And it also ignores ambiguity and conflict in law, as it were. Now, if you take the positivist and discussion, particularly H.L.A. Hart, Professor Hart, as we have noted already, he provides the view that law has a core of certainty and a penumbrum of uncertainty. So like you have like the core, the core of a certainty, and then around it, penumbra of uncertainty. So in the core, Hart says that rules apply clearly in the core of certainty, and there's no discretion by the judge or the courts. In the penumbra, that is outside the, after the core, and then the penumbra, rules are unclear, and judges must exercise discretion, or what we call like the gray areas, as it were, and judges must exercise their discretion. So, in Hart's view, when it comes to hard cases, judges legislate interstitially, that is, they create law within limits. Judges create law within limits in hard cases, according to Hart's view. So if you remember, you talk about the open textual nature of law, and he says that legal language is inherently open textual, that we use language to write or present the law, and language is fluid. Language is very elastic. Language is very elastic. And because language is very elastic, it certainly affects the law. So general terms cannot anticipate all situations. Social life is complex and changing. So for example, what counts as a vehicle in the statutes binding vehicles in a park? If you take Ghana, for example, something called Abubuya, something called the Pragia, these vehicles were not known about 10 years ago. So if you have, for example, the third-party motor insurance law, okay, one of the early legislations in the latter part of the 50s. Now, Pragia carry passengers like taxis and trotro. So the vehicle mentioned there doesn't only refer to Pragia, as it were, for example. So those are some of the things that we are talking about. So judges must interpret and choose. Now, Joaquin strongly rejects Hart's idea of strong discretion in the so-called hard cases. And Joaquin makes the point that even in hard cases, judges are not free to create law. Instead, there's always a right answer derived from legal principles. And Joaquin has told us, as we have studied already, that law includes principles, not just rules. Noah said that law is made up of rules, but Joachim will say that law is not made up of only rules, but it also includes the principles. Judges must interpret law as a coherent moral system. And what this implies is that judicial decisions are constrained by principles. And judicial decisions are not as of legislative choice. So let's keep that in mind. So all the things that we read earlier on by Joachim, with his law as integrity, they apply to our present discussion mutatis mutandis, or necessary modification. So Joachim introduced the idea that judges should decide cases in a way that best fits and justify the legal system as a whole. And the method involved here will be that judges interpret past decisions, identify underlying principles from those decisions, and apply them consistently. So for Joachim, it's not a matter of discretion, which has said should be exercised in the penumbra cases where we have that gray area of uncertainty. For Joachim, discretion is replaced by interpretive reasoning. Interpretive reasoning in the sense that the judge will have to interpret the past decisions and then try and identify the underlying principle from those decisions and then apply them consistently to the new cases before him or her. Now, legal realists, on the other hand, take a more radical position as far as discretion is concerned. Their view is that judicial decisions are influenced by personal values, social context, and political consideration. And for that matter, some of them will say that the law is what judges had for breakfast. I mean, to put it literally, the law is what judges had for breakfast. It's a sort of a caricature, but illustrative of what legal realists think about judicial discretion. So for them, formal legal rules do not undermine outcomes. Discretion is wide and often hidden. Now, are values relevant in judicial decision making, by the way? Can judges avoid values? There are situations where values arises. Constitutional interpretation. Now, as we speak now, we have before the Supreme Court the case of religious freedom, religious expression in our secondary school. I'm talking about the Wugihe case. And because it's sub judice, I'll not say anything, but just to let you know how issues of values may come up in constitutional interpretation, or how to balance competing interests and policy sensitive cases, as it were. So the key question is, should judges explicitly acknowledge values, or should judges conceal them within legal reasoning? In other words, should judges be explicit about values, or judges should not be explicit, although it can operate on their mind when making a decision, as it were? So let's keep that in mind. Now, the last but one matter I want to touch on is judges and lawmaking. Let's explore that a bit deeper before we go. And the classical question, as far as judges and lawmaking is concerned, is this: do judges make law, or do they merely declare it? Do judges make law, or do they merely declare it? Now, the declaratory theory of law, what does it say? The declaratory theory of law holds that judges do not make law, They merely declare what the law has always been. And the philosophical basis of that position is that law exists independently of judicial decisions. That is to say that before the judge makes a decision, the law is already there. So if the judge is making a decision, the judge is only telling us that which is already in the law, and the judge is not making any new law. Judges discover rather than create legal principles. So that is a declaratory theory. And the implication for adjudication is that judicial decisions are retrospective in the sense that they state what the law was. Judicial decisions are not creative. Now, the point or the purpose of this declaratory theory is that it's preserve separation of powers and say that it's not the business of the court to make laws. The law have been made already. And all that the courts are doing is to tell us what the law is. It also protests judicial legitimacy and avoids perception of judicial overreach. But the declaratory theory has significant downsides in the sense that it's largely fictional. Now, new cases arise. Law cannot anticipate every situation. We have novel cases, and novel cases might not have been anticipated. Again, we may have conflicting authority. Judges must choose between competing rules. So you cannot just say that judges are just declaring the law. And courts clearly develop new principles over time, as we see. So the declaratory theory, in a sense, conceals the creative role of judges. Now, we also have the other theory, what we call the lawmaking theory. The lawmaking theory's core claim is that judges do, in fact, make law, especially in difficult cases. So, what are those instances in which they will say that we have a judicial lawmaking? So, for example, in developing the common law principles, well, if you go to law of tort and probably contract, you get a number of examples. Even when it comes like a customary land law, as it were, customary land law, alienation of family property, you see how the principle will be evolving. And again, interpreting statutes or expanding or limiting precedents. So, for them, judicial decisions are not merely applications of law, they are sources of law. So that's the point that they want us to understand. Yeah, so I'll be taking questions, if any, before we move on. Any hand up? Okay. Eric. Yes, Eric. Oh, sorry. Yes, Eric, you can unmute.
Good morning, my Lord. My Lord, my question has to do with when it comes to adjudication of justice. We know obviously the Supreme Court has a review jurisdiction where it can depart from its previous decisions. I want to know, please, what happens if the previous decision led to the conviction of an individual? When they review their decision, are they going to rest it on the issue in order to administer justice? That is my first question. And please, the second one is about the exclusive jurisdiction of the Supreme Court when it comes to the interpretation of the Constitution. Can we therefore say that in our Ghanaian settings, not all judges have the power to interpret the law in such a way that it is reserved for only the Supreme Court, and the other judges are only supposed to apply the law, except in Makanka's case, where there is no ambiguity. Thank you.
All right, thank you, Eric. Okay, good. So to start with, when it comes to changes in the law, if the change in the Supreme Court decision related to procedure, if related to procedure, then the position of the law is that nobody has a vested right in procedure. So you cannot say that because of the precedent which has been departed, which the Supreme Court has departed from, automatically all convictions which were made 20 years ago are going to reverse. No, it doesn't work that way necessarily. If it's about like the substantive law, then that one is different. So let us note that. And then two, when it comes to constitutional interpretation, as you rightly said, we have the exclusive original jurisdiction of the Supreme Court, and all other courts will have to make reference to the Supreme Court where a constitutional matter arises, as it were. Of course, the Maikankan principle you stated is not without controversy. We have a school of thought, some Supreme Court judges who actually hold the view that all matters relating to the Constitution must be pronounced upon by the Supreme Court, except where you're only just applying interpretation of the Supreme Court already to a matter. Yeah. So that is it. Yeah. So apart from of course, the Chapter 5 of the Constitution, Fundamental Human Rights, which the High Court has also got original jurisdiction. It's only the Supreme Court has got exclusive original jurisdiction with respect to interpretation and enforcement of the Constitution. Yeah, so you are right in that. Yes, any other? Okay, so we will be ending this particular topic now.